Hello everyone, welcome to Kamadinola Academy. We are discussing on the subject contract 1. Okay. So define contract, explain the essentials of valid contracts. All agreements are not contract, but all contracts are agreements, but all agreements are not contract. Explain with reference to essentials of valid contract. Okay, this is to our questions. See, the term contract is derived from the Latin word contractum, which means drawn together. That means it is brought together. Two parties have come together. A contract brings or draws the parties together and establishes legal relationship between them. An agreement is the basis of contract. An agreement comes into existence whenever one or more persons promise to one or others to do or not to do something. An agreement which can be enforced through the courts of law is called a contract. So let's get into the definitions. Salmon, Pollock, and what according to the act says the definition is. So Salmon defines a contract as an agreement creating and defining obligation between the parties. So it is creating and defining the duties of the parties. So what Pollock says then, every agreement and promise enforceable by law is a contract. Whichever is allowed by law is a contract. So now let's get into what section, what article say, what the act says about the contract. Section 2H of Contract Act defines a contract as an agreement enforceable by law. Sir William Anson defines a contract as a legally binding agreement made between two or more persons by which rights are acquired by one or more to act or forbearance to on the part of other. If we observe the above definition, we find that a contract consists of two elements, an agreement and it should be enforceable by law. So in definition, all the three definition you see, there should be an agreement and it must be enforceable by law. Okay. That is what the definition says. All definitions you put together and see. So now what are the essentials? If to say this is contract, what are the essentials of that contract which is a valid contract? Let's get into it. The following are the essential elements of the valid contract. Offer and acceptance. Offer and acceptance. In order to create a valid contract, there must be a lawful offer by one party and lawful acceptance of the same by the other party. Intention to create legal relationship. There must be an intention to create the legal relationship. Okay. There must be an intention among the parties to create a legal relationship. In case of social or domestic agreements, the usual presumption is that the parties do not intend to create legal relationship, but in commercial or in business agreement, the usual presumption is that parties intend to create legal relationship unless otherwise agreed upon. So let's see one example of case law, that is Blaffer versus Blaffer. See, in this case, what happened? This husband, no, he'll tell the wife that I'm going abroad and I'll pay you 50 rupees every. I'm sorry, I'm ill. This husband will tell the wife that every month I'm going abroad and every month I'll pay you rupees 30. Okay, so what this husband will do? He'll go to abroad and he'll forget. He'll not pay. He'll not pay to the wife for rupees 30. So what she'll do, she'll file a suit against the husband saying that I want 50. He promised me that he'll pay me 50. I'm sorry, 30, 50, whatever. But he didn't pay me. So the court told that it is a domestic agreement and the promise made by the husband in case is not to create a legal obligation. So court told that there is no legal relationship. That is what the case is. Lawful consideration. An agreement must be supported by lawful consideration. Consideration means something in return. The consideration must be lawful. Example, A promises to obtain employment in public service for B and B promises to pay 50,000 rupees. This agreement is not enforceable as the consideration for it is unlawful. Capacity of the parties who are entering to the contract should be of sound mind and should not be disqualified by law and should be the age of majority. Okay. Free consent. The consent should be free. You should not threaten him and take. Okay. So for example, A who owns two cars, one Maruti and the other Indica, offers to sell B one car. A intending it to be Maruti, but B accepts thinking that it was Indica. There is no free consent and hence no contract. Lawful object. It should not be illegal or immoral or opposed to public. Okay, the object should be lawful. Certainty of meaning. So see, now the terms and conditions prescribed must be correct. If I say I will sell you 100 liters of oil, I have not mentioned which oil is there. Whether coconut oil or cooking oil, I have not mentioned. So this agreement is not enforceable because it is lacking in certainty of the meaning. Possibility of performance. The agreement must be capable of being performed. It should not be something which cannot be performed, which cannot be impossible to perform, like that. Okay. Not declared to be void or illegal. Agreement in restraint of marriage, agreement in restraint of trade are the examples for that. So legal formalities. An oral agreement is perfectly valid contract except in those cases where written registration is required by some provisions. In India, writing is required in sale, mortgage, lease, memorandum of association, article of association of the company, etc. In some cases, a contract has to be attested, registered and stamped. So formalities have to be followed. Thus, where there is a statutory requirement that a contract should be made in writing and registered, they require by legal formalities should be fulfilled with all the elements mentioned above must be present in order to make a valid contract. If any one of them is absent, the agreement does not become a contract. So all agreements are not contracts, but all contracts are agreement. Please do subscribe to Kamadhenu Law Academy. We are giving exact notes, we are giving proper notes, and we have recorded classes also, and it will be helpful for you to write the exams. Okay, thank you. If any doubt, you can comment in the comment section. Thank you.